Welcome to FDVN Law Firm. In today's video, we will introduce the new lesson, Express and Implied Terms. Express terms are set out and stipulated expressly in the contract. For example, the seller will within a period of 6 months from the date of delivery of goods, where goods which are proved to the reasonable satisfaction of both parties to be damaged or defective or not to comply with the agreed specification due to defects in materials or workmanship or to faulty design, repair, or at its sole discretion replace such goods, subject to the following conditions. A condition is an essential term of the contract. If a condition is not performed, it may constitute a substantial breach of contract and allow the other party to repudiate the contract, that is, treat the contract as discharged or terminated. It may also give rise to a claim for damages. If all the conditions are performed, the contract is performed. A warranty is a term which is secondary to the main purpose of the contract. A breach of warranty does not in itself permit the other party to treat the contract as discharged, although it may allow the party to sue for damages in the event that loss is suffered. When deciding whether a party is entitled to repudiate a contract, courts may try to determine the intentions of the parties with regard to the terms. For example, the courts might look at the commercial importance of a term in relation to a particular trade, and examine the seriousness of the consequences of a breach. If statements made by parties before a contract is made are not intended to be legally binding, for example the stated age of an object offered for sale, they are usually known as representations. If a representation later turns out to be false, this cannot give rise to breach of contract but instead to a possible action for misrepresentation. B. Implied term. Implied terms are not made express within the contract but may be implied into the contract in the following ways. By custom, a term can only be implied into a contract by custom if there is no express term to the contrary. These may be terms which are customary in the market in which the contract is made or have been in previous dealings between the parties. By statute, various statutes imply terms into different specific contracts. For example, the condition that employment contracts will be automatically transferred is implied under statute in the contract for the sale of a business. In a sale of goods contract, there are implied conditions that the seller has the right to sell, that the goods correspond with the description, are reasonably fit for the purpose, and are of satisfactory quality. A contract for the lease of a furnished flat automatically contains a specific implied term that the flat be reasonably fit for habitation, by common law, by the intention of the parties, if it is a term which is necessary to make the contract work. 2. Practice. 1. Replace the underlined words and phrases in the written contract term below with alternative words. 8.1 In the situation that the goods have been manufactured by the seller and are found to be broken or imperfect, the seller shall mend, or if it chooses to do so, substitute defective goods free of charge in less than 2 years from the time the goods are received, depending on the following terms. 8.1.1 The buyer notifying the seller in writing immediately upon the faults becoming apparent. 8.1.2 The defect being because of the incorrect design, materials, or workmanship of the seller. 2. Complete the definitions. There is more than one possibility for one of the answers. A. Breaking a contractual condition. B. Refuse to carry out obligations under a contract because the other party has not kept to the essential terms of the contract. C. End a contract. D. Carry out all the terms of a contract. 3. Complete the table with the appropriate noun form of words taken from A opposite. Put a stress mark in front of the stressed syllable in each word. The first one has been done for you. 4. A solicitor is talking to her assistant about a phone call with a client. Replace the underlined words and phrases with alternative words and phrases from A and B. He says the terms of the guarantee have been breached and his business wants to sue for compensation. The contract says that if the goods are found to be defective, they'll be repaired or replaced, and the seller is refusing to do either. Of course, these conditions may also be set out in a law. We'll need to look at the contract to ensure there's no written term saying the opposite. Can you check if his company has had earlier agreements with the seller?